So today we'll talk about e-commerce lawsuits. There are certain terms that sellers think are generic. For example, Emoji, Frisbee, hula hoop. They don't realize they're actually trademarked terms and they're not allowed to use them. Essentially, you have two ways to deal with the lawsuit. So you either litigate, you either go to court and fight it there, which is costly. That's not the common way to deal with these lawsuits.
The poop!
Yeah.
So many issues with poop! So, Leon, the Magnificent.
Thank you. Thank you.
A friend. A partner. We've wanted to have you on the podcast for a while now, and finally it took some convincing, but here we are. So persistence is rewarded. Remember that. So, Leon.
That's true.
What are we talking about today? Why are you here? Honoring us with your presence.
Well, first of all, I've been a fan of the podcast for ages, so it's great to be on.
I made him say that.
So today we'll talk about e-commerce lawsuits.
Okay.
That affect eBay, Amazon accounts, and other selling platforms.
What type of lawsuits?
IP infringement lawsuit.
Okay.
Yeah. And usually the way it starts is as a seller, you get a notice from Amazon, for example, telling you that a TRO has been issued, a temporary restraining order, which means you cannot get your funds out from Amazon.
You can continue selling your account, your operation. You just can't reach your fund.
Exactly. That's right. And usually there will be an ASIN, a selling page that's listing that's blocked, which is the ASIN that's subject of the lawsuit.
Okay.
The infringing product, and then you'll need to resolve it by contacting the attorney for the plaintiff to settle the case, the complaint.
So I'm a seller. I wake up one day. My funds are frozen. I can't get to them. I can't withdraw my money.
Mm-hmm.
I contact Amazon and ask them what's going on. And then in reply, they tell me about the TRO. Or I wake up in the morning and I see a message from Amazon completely initiated by them. By the way, there's a TRO against you. Won't be able to withdraw your funds.
Yeah.
Tell me which of these scenarios fits the actual reality.
Yeah, it's a great question. So it's the second scenario. Yeah.
Oh, the second one. So yeah, Amazon actually initiates it.
So you get a notice from Amazon telling you about the TRO, and they'll also give you the contact information for the plaintiff.
It's interesting that the plaintiff managed to file a lawsuit and not even notify me, the defendant, or one of them, of the ongoing lawsuit, and Amazon is left to notify me.
Yeah, that's right. Usually it's just they file this lawsuit not only against you, but against tens, dozens, or maybe even hundreds of sellers. But you'll be identified by the store name, and that's how it's done.
So I can find myself as a defendant multiple times if I have several stores?
Potentially, if you're infringing
if I'm selling the same ASIN in several Amazon accounts, I will be named as a defendant several times.
Yeah, you would. Yeah.
Okay. What's a typical seller that is sued? Is it private label? Is it wholesale? Give me some background on that.
Well, you could be sued as a private label.
Like what? Give me an example.
For example, there are certain terms that sellers think are generic, and they don't realize they're actually trademarked terms, and they're not allowed to use them. So, for example, Emoji, Frisbee, hula hoop.
So if I get this lawsuit, it doesn't necessarily mean that I'm a bad player. may have not even realized that it was a trademark. It's a word, an everyday word that I use in our everyday jargon, and I thought it was a descriptive term or whatever, but it turned out to be a protective term.
Yeah, but unfortunately, that won't help your case with the plaintiff and in negotiating a settlement, because you're still considered to be infringing of the trademark.
So intention has no relevance
No.
as a defense.
No, it won't help you. You can try to play that card, but
Would it help me in settlement?
no.
They don't care?
They're not very sympathetic. Yeah.
Okay, so give me an example of funny situations of lawsuits, like funny marks or something that resonates in your mind and makes you smile when you think of it. Make it juicy.
I know how your mind works, so I think I know where you're going with this.
I don't know what you're talking about.
So I think you're referencing the emoji poop. Is that it?
The poop.
Yeah.
So many issues with poop.
Yeah. Okay. So would you like to elaborate on that subject?
Well, people don't realize that the image of the poop is a protected trademark that belongs to Emoji. And they got sued for having all kinds of poop products or using that image or that emoji in their description, in their product, on their packaging. Some even had a cushion that looked like a poop, and their entire product was just poop. I think it was a little, I know it was troubling because they got sued, but it was a little humoristic to explain to them that their product itself is the infringing part, and no, they cannot use that product again with the poop, even if they remove the word poop. So yeah, how did that end?
Emoji is highly litigious, and they go after a lot of sellers who not only use the actual emoji drawings, but also the word emoji itself. Yeah, so don't put that in your listing title or anywhere on your product detail page.
Yes. Also, the emojis themselves are available everywhere. They're on your phone, they're in your text, they're on your keyboard.
Yeah.
And to think that some aspects of your keyboard are protected, it's counterintuitive. It goes against your logic. The letters in my keyboard are not protected, but let us not forget that it's a company and they make money out of it.
That's right.
And anywhere in your keyboard, it's through some sort of license or some sort of an agreement, and you can't willy-nilly take the poop emoji and use it for your benefit. Those were my patriotic words on poop and emoji and intellectual property and e-commerce. So I've been sued. Now what?
Essentially, you have two ways to deal with the lawsuit. So you either litigate, you either go to court and fight it there, which is costly, and that's not the common way to deal with these lawsuits. So the more common approach and what makes sense basically is to settle the case and to negotiate a settlement agreement.
Can you tell me a little bit about what is the incentive behind these lawsuits? What are the plaintiffs really looking for? Do they intend to go through a full trial with each and every defendant? Isn't it also costly to them?
Yeah.
I mean, how does this process work?
Yeah, that's also a great question. It is costly to them, and they have a couple of objectives. So first of all, obviously they want to get settlement payments from the defendant as a condition to sign an agreement and release the hold on the account. So that's number one. And number two, for the defendants that choose to do nothing, not to fight it, not to go to court, not to litigate, and not to settle, they'll get a default judgment. And
what would that?
Yeah.
What's the consequences of a default judgment?
A high amount of damages will be rewarded to the plaintiff, and they can use that with Amazon to say, okay, here's the order we got from court. Now now you need to release all the money that's frozen in this person's account to us.
I want to work on a little bit more on the word default.
Yep.
It's a very legal term. It's
Yep.
jargon. What does it
You're right.
mean? It means I lost? It means
Yep.
I gave up? I forfeited? What exactly does default mean?
Well, default basically means they're going to give the plaintiff what they asked for because you made no appearance in court, you did not settle, you did not defend yourself. So the plaintiff will get the damages that they're asking for, and the hold on your seller account will remain, and that's basically what it is.
So let's say I got a default. Worst case scenario, I didn't even realize that I was sued, or I didn't take that email seriously. Maybe I thought it was spam, or who would sue me?
Mm-hmm.
I didn't mean to do anything. And the money was withdrawn from my account. Is my account suspended? After the withdrawal, is the funds open again? Can I go about my business? Put me in a little bit on the mindset of what's going on with this seller that didn't take this seriously and didn't protect themselves and didn't defend their stance.
This is an approach that some sellers who don't want to continue selling on their store.
Selling that product or selling in general?
Selling in general. Yeah.
Okay.
They don't mind. They just want to walk away from their business. They've lost too much money anyway. The product wasn't successful, and they don't want to continue operating their e-commerce store. So they'll choose to do nothing, and knowing that a default judgment will be awarded against them. And sometimes they're non-US sellers, so it's harder to come after them. Especially if they don't have any funds frozen in their account, it'll be hard to get anything out of them.
Are there other consequences other than the financial weight or the fact that I lost my Amazon business to a seller that's outside of the United States and has this default judgment against them? Are there consequences in the real world? Real world?
Well, theoretically, that option should be available to the plaintiffs. But in theory, it's a very low risk. It's not something that we've seen happen.
What option? What would happen? What can the plaintiffs do?
Well,
so they have this default against them. Now what?
The realistic thing that will happen is that they'll get whatever's frozen, whatever funds are frozen in your seller account.
And case closed?
They'll get that, and that'll be it. From our experience, it ends there. So a question I get a lot is, will I have trouble getting into the U.S.? And so, again, in theory, perhaps, but it's not something that we've seen happen. Usually, with the plaintiff, it ends there, meaning with the funds that are withdrawn from the seller account, and that's it. So,
just to summarize, in theory, a plaintiff that holds a default judgment against the seller has an array of tools. Legal tools that they at their disposal. They can, stop you in customs or when you enter, whatever. But that means that they need to put in the effort.
Exactly.
And it's costly to them too. And it's just not worth it, usually, for them to go after each and every small seller.
Yeah, exactly. Usually with the, many of the defendants are just small-time sellers, so to speak. So just the effort and the amount they'll invest in it, just not worth it.
So I wouldn't recommend a seller to ignore this type of lawsuit, even if they don't have a lot of money, just because, in my opinion, having this, cloud of uncertainty of what would happen in the future with me, I would rather settle it, especially if, like you said, you gave an example of sellers that don't want to continue their Amazon business. Even more, I would say, settle, get this over with, and move on with your life. Don't leave this open window of uncertainty, leveraging over your head.
I completely agree. And that's what I would do as well. And, you don't want to leave any loose ends. So certainly what I would recommend is to settle, just to have this behind you, and know that it won't come back in the future. I just want to add one more point regarding the default, that even if there was a default judgment issued against you, you can still settle with the plaintiff at that juncture. And sometimes it's even easier to do that after a default has been issued, just because the plaintiff may find it difficult to go after your funds then.
Tell me what happens after you reach a settlement.
Yep.
What's the most common question that you get from sellers? And what difficulties do they encounter? How did you live past that date of the lawsuit and the settlement? Does anything change in the way that the seller needs to run their business?
One thing is, usually you won't be able to continue selling the ASIN that was affected by the lawsuit. So the ASIN that's considered to be infringing, usually that will continue to be suppressed. And
is a license ever an option in these settlement agreements, or they're not interested in providing you with a license and
sometimes,
making it legit?
Yeah, sometimes. For example, when a utility patent is involved, the plaintiff will sometimes want or insist on a licensing agreement rather than just a one-off settlement payment. They can get paid as well for each unit that you sell going forward. So that will be their incentive to allow you to release the ASIN to you, and that you can continue selling products under the ASIN.
Yeah. It's more likely to get a license for a patent versus a trademark, because a trademark also kind of has some sort of endorsement from the brand or some sort of association of approval.
Yeah, exactly.
And brands don't want to reward sellers that infringe their trademark with that association.
Yeah,
I would assume.
That's right. That's right. A lot of IP owners or trademark owners don't want their brand diluted by, what they see as inferior products being sold under their trademark. They don't want their brand associated with that product.
How long does this process usually take before I can put it behind me? If I get a lawsuit, I'm a seller, what do I do? I decide to fight it, or I decide to not ignore it, which is the wise choice. I contact an attorney. Now what?
It really depends on each case. And, some cases can be settled quickly. It also depends how responsive the attorney on the other side is. Their objective, the plaintiff's objective, is also to settle. They usually want a quick settlement as well, but it also depends on the settlement amount. This usually depends on how many units you've sold of the infringing product, assuming it is infringing. And it's important, by the way, that the first step when you enter in negotiations is to receive all the information about the lawsuit, meaning the complaint, to see what IP is asserted as being infringing, to look to analyze the product and to see if there is an actual infringement.
Does it matter how much money Amazon is holding in my account?
Yeah, it does. The questions a lot of sellers ask is, how much money will they ask for? It depends on a few factors. So the amount restrained in your account, that's one big factor, okay?
In the settlement.
In the settlement. So that's one thing they look at. And also the number of units sold of the infringing ASIN. And also, how aggressive the brand or the rights owner chooses to be. Yeah.
Is there a chance that I would be heard if I have a lot of money on in Amazon, but I'm going through financial struggles, I have issues, any of these mitigating circumstances, something that would they listen to me if I have a lot of money on Amazon, or there's no way?
Well, it may be hard to get the plaintiff to be lenient if they see that you have a substantial amount frozen in your seller account. But, in certain cases, when you, if you're indigent, if you have loans, if you have...
Yeah, I could have a lot of money, but that doesn't reflect my debts.
That's right. In some cases, the plaintiff may agree to a lesser amount in the settlement if you can show, circumstances of hardship, financial hardship, and it's certainly worth trying. Yeah.
Okay. So I'd like to end with a little bonus for viewers. One of the trademarks that a lot of people use and don't know that it's a protective term is Velcro.
Mm-hmm.
And from the perspective of the brand, correct me if I'm wrong, a brand needs to constantly work on protecting their trademark so it doesn't become generic,
Mm-hmm.
and then they lose that protection. From the perspective of a trademark owner, the fact that you have this monopoly doesn't mean that it's forever. You have to work on it. You have to renew it. You have to do steps to protect it, correct?
Correct.
The brands that are suing,
Yeah.
they're not all bad guys, right? Why are they doing this? Why are they going after these sellers?
Yeah.
Why are they going after infringers? What's their incentive other than, money?
A lot of these are big time sellers that sell huge amounts of infringing products that, in the eyes of the plaintiff or the rights owner, dilutes their brand, and that they see that as as hurting their business, and they want to rid the market of those products. That they don't want those inferior products associated with their brand, with their name. So that's another reason for filing these lawsuits.
Okay. What does it mean that your mark is diluted?
It means that as a brand owner, you've worked hard to build goodwill and reputation in your brand, and consumers associate that with your brand, and you don't want the market flooded with inferior goods, because consumers will think, I'm buying a legit product here, an authentic product, which is actually a knockoff, which is actually counterfeit.
So, to our viewers out there, if you Google or go to YouTube and write down Velcro video, there's a really funny attempt from the Velcro company to, first of all, explain why they were removing infringers and going after sellers. And so they did a video with them all breaking in song and dance about the reasons why. And then there's a second video follow-up where they got all kinds of hate mail as a result and as a comment to their initial video. So they did another video that is completely comprised of the remarks that and the hate speech they got against them for enforcing their rights. But I think that kind of gets the point across. So if you have a few minutes to spare, look at the Velcro videos. I think that would summarize this podcast well.
Yeah, and at least they have a good sense of humor.
Exactly. And then that's life, humor. What else can we do? Thank you, Leon, for being with us. I hope this is the beginning of a beautiful podcast friendship. And hope to see you here again with your smile and insights. And if you need anything, we're here at your service. Have a great day.
Thank you for having me. It was an honor being here, and I hope we can have another podcast together, Shira.
Absolutely.
All right.
Sooner rather than later.
Sooner.
Okay.